This time, Mr. Issa.
Thank you, Mr. Chairman.
And Mr. Issa is on your funding bill. He's on the funding bill.
Yes, and I mentioned that in my opening remarks, Congressman Issa.
This should help as I batter the witnesses with questions. First of all, Mr. Chairman, I'd like to ask unanimous consent that a letter dated July 30th, 2013, which went to the chairman both in the House and ranking members in the House and the Senate, be submitted into the record. I'm going to speak on.
Without objection.
Thank you. Mr. Kramer, your company was on this letter, which is no surprise, in support of expanding CBM, to a certain extent supporting the STOP Act, although not stating it. You obviously believe there needs to be a low-cost alternative to narrowing the claims or eliminating overly broad and poorly executed patents. Is that correct?
That is correct, Congressman. Yes.
And by definition, if you've got bad patents, Mr. Armitage, I'll give you a chance to respond, but if you've got bad patents in one category and they're being adjudicated, if you will, through a low-cost system, and you have others that are being ignored, but they're being executed on in court, isn't that inherently a flaw in existing legislation not to have picked them up?
I think it's a flaw in existing legislation not to provide low-cost alternatives where you have these bad patents, whatever their technology, and you don't provide the ability in a broad way to go back to the patent office to address those things. And post-grant review and inter partes review have limitations in scope.
And I certainly agree. Mr. Armitage, you talked about 100 years of a standard. You're familiar with, until maybe 20 years ago, less than that, about 20 years ago, means plus function claims allowed somebody a quick and dirty way to describe an invention and then make it extremely broad under the doctrine of equivalence. Do you remember that?
Was it only? I'm sorry. I do remember before the Federal Circuit clarified how Section 112.
They struck it down. They absolutely killed means plus function as a way to get broad patents while narrowly defining them, didn't they?
I don't want to get into a debate, but I still urged clients when I practiced to use means plus function claims because
as long as all they wanted was the means that they were showing, correct?
Well, I'm going to say you're substantially correct, and afterward we can discuss the exceptions.
Well, Mr. Campos, I lived under those old means plus functions as an inventor and as a manufacturer, and I saw people who took a couple of relays and popped them together and threw a patent with a line drawing out and then said, darn it, your microprocessor or your complex gate array with thousands of gates in it or huge amounts of memory, it's the equivalent, and tried to claim that because the output of the device did the same thing, that it must have the same input. Do you also remember that era of overly broad interpretation that, quite frankly, paled in comparison to what's happening today with business method patents, isn't it?
I certainly do, Representative Issa.
And not that you're that old, but I am.
Over breadth associated with 112.6, what definitely was a problem. It has been significantly reined in.
Well, it has, but there's a new generation of workarounds, just as the eBay decision is being worked around by going to the ITC whenever possible to get an exclusion, because the court, when they set a standard for injunctive relief, they didn't consider that there's an entity just down the street that only does effectively injunctive relief. It's the only tool, and they use it constantly because they have to. So, legislatively, certainly we have a similar challenge that the court only can consider what's brought to it, while we can consider all the problems that are brought to us. Mr. Campos, you have a tough job, but under the current law, if you do not have a standard to look at prior art as broadly as prior art is expressed when it comes before the Patent Office, don't you inherently find yourself in a situation in which examiners are constantly being told that prior art is narrow? Well, in fact, if that same prior art were coming before a court, it would, like the old means plus function, suddenly be expansive. Isn't there a need for a standard change that makes it clear that you must consider prior art as broadly as possible from a standpoint of exclusion? And that's not currently the case. The examiners are often faced with claims that something means very little, and with relatively little recourse to argue that point.
But are you asking whether the court should have to move to the broadest reasonable interpretation standard?
No, actually, my point is the broadest reasonable interpretation standard should apply to what has already been invented. And one of the challenges is it's applied to your consideration of what an applicant is entitled to rather than the exclusion. The whole point is that and you mentioned earlier the obviousness standard, we have a problem, which is if anyone of ordinary education, not necessarily ordinary skill in the art, but if ordinary education reads the existing patents and then looks at a new patent, most often they search endlessly to try to figure out what's new. And they find a little nuance. You know, I had a relay and I had a car, and now I've got a relay, a car, and a mobile radio. And they say, aha, it's the mobile radio. Or is it? The fact is, we have a fundamental problem that regularly your examiners have a standard which, under the scrutiny of an opposition from an outside party, bringing in the actual and real experiences, the actual products and what they do, are successful in narrowing patents dramatically on a regular basis. Isn't that true?
I see. So you're asking about the inferences that examiners are able to draw. Certainly, in my view as a citizen, that has improved since KSR and some of the cases that have interpreted it. Further refinement clearly is needed. I would agree with you, Congressman Issa, that providing the USPTO with greater flexibility to apply inferences and to expect applicants to respond to those in order to clearly specify patent claims is good for the whole system.
Now, when I was learning about patent law as both an inventor and as a manufacturer, you know, I understood that you could be sued for your making, using, or selling a product. But I don't think I ever considered that of these 40 companies, that the ones most concerned with people with great new technology would be being sued. I didn't think of Eddie Bauer, Safeway, J. Crew, Overstock.com, the Kroger Company, Macy's. Now, I've been in a lot of Macy's. I've been in Kroger. I've been in Safeway. Isn't one of the problems that this committee has to deal with is the growth of deep pocket large companies? And Mr. Poe talked about little companies, and I was a little company, and I appreciate the cost of litigation. But isn't one of our problems the idea that incidental use has made companies large targets just because they're using a product? I've got Wi-Fi in my store, and I'm going to be sued as a result as often. And isn't one of the most important things that we have to do in the legislation we're looking at today to make sure that the manufacturer, ultimately the entity, the single entity that probably is in the food chain, is the entity that deals with the eventual use of their product, rather than being sued in jurisdictions all over the country simply because I put 100 Wi-Fi units into my store to help my customers, or you know, my airplane serves a certain type of food that somebody finds a way to have a patent on. Mr. Campos, I'll start with you, and then I'd like to go to Mr. Kramer.
Yeah, so that's the stays for customers, and as we've discussed, I certainly am in the group that would agree that retailers, right, the Krogers of the world,
particularly when they're not selling the infringing product, but simply using something that somebody has put through.
If they're using it to run their Wi-Fi's, or if they're selling it, end users, you know, this would be Kroger in the role of an end user, or Kroger in the role of a retailer, should be able to stay out of litigation. The trick is letting them do that in a way that doesn't also let every other party in the manufacturing value chain stay out of litigation, because if you do that, then you significantly devalue patents for companies in, you know, whether it's in auto alarms or any other industry where you've got, you know, lots of parties adding value to components, making more and more aggregated products. you don't want to devalue the whole patent system. You do want to protect the end users and the retailers.
Well, and I know the chairman's being understanding about my time, but the intermittent wiper case was certainly a great case under Averill Cohen, in which it added value to the car, and some understanding of entire market was the case. I'm pretty sure that the delivery of groceries at a Kroger's or a Safeway is not so dependent on Wi-Fi, and I certainly think that there's a fair test of entire market, but that's not the test that currently these trolls are using when they choose to go after deep pockets. Mr. Kramer, although the chairman may allow others to answer, I'd like to just have, you've been used as a big company, but ultimately, aren't you just a big target, and isn't that part of what you see every day?
Yeah, thank you for that question. That is absolutely true. Since 2007, we have received roughly 70 patent infringement complaints. So that's a huge increase in our litigation burden, particularly when compared to the first 12 years of the company, where we had at any given time 2 to 3 cases on our docket. Now, I mean, we settle cases, we get new cases on our docket at any given time is 20 to 25 cases. So we are a huge target, and I think that has to do with the nature of our technology, the fact that you can see pretty easily what we do, and the fact that software patents are, quite frankly, there are a lot of them out there on a lot of different things, yeah, I can't emphasize enough how our situation has changed over the years.
Thank you. Mr. Chairman, I appreciate your indulgence, and I thank you for all the hard work that the committee is doing to try to improve patent qualities and particularly empower the PTO to do so.
Thank you, Mr. Issa. I wasn't really concerned. You did spend 12 minutes, but you, at the start,
a darndest thing,
almost,
I just don't have a
I've never
clock.
heard you badger a witness, but you came close on Mr. Armitage.
Well, Mr. Chairman, if you come next door, we're accused of doing that to a number of people.
Oh, no, I've never noticed.
No. Eric Holder said he was a pleasure being here the last time. But, Mr. Chairman, I do think this is so important. I appreciate the extra indulgence of time.
Thank you.